Reputed builders selling flats based on RERA approval. We as owners trust that stamp of approval and buy our flats. But still, many builders sell their flats without a completion certificate in terms of the lift certification, electrical certification, effluent treatment plant, so on and so forth. Now, if we as owners know that something is under construction and we buy it without CC or OC, then what happens is it's like a deformed child born. The residents cannot do with a deformed or handicapped child which is born, because neither we have the money nor the wherewithal. And the builder escapes from the situation saying either he has gone bankrupt and so on and so forth. Does the law help us to reduce the gap between the law on one side and enforcement on the other side? We have to reduce this gap.
Please. Hello. Give one mic here, no?
Yes, I'm giving that.
Sorry, I asked sir that I'll answer because I'm strictly on this issue for last so many months. I feel I have a solution, but somehow I have not been able to convince people. In Karnataka, the definition of occupancy certificate is different in different acts at different times. In RERA Act, the original Government of India Act, the definition of completion certificate, completion and OC is available. In Karnataka, the planning authority gives occupancy certificate, which I understand that occupancy certificate means that the project is or the building is completed as per the sanctioned plan, meaning thereby that structurally the towers are completed. On that, the planning authority gives completion. I'll seek your indulgence. And the builder says that now I have OC, my responsibility is over, it stops. Wherein the RERA Act or the RERA goes little beyond. It says that what you have promised to the home buyer in the form of assurance in agreement to sell and the brochure, unless you complete that, the project is not complete. So there has to be something like closure policy that the OC has been given by the planning authority, that building is okay. On that basis, they will get permanent power supply, permanent water. They can give virtual handing over to the allottees for doing their interiors and all. But the project is not completed. So the builder's argument that with OC the project is completed, in my personal opinion, is not correct. The project is completed with the closure, which means what all you have promised to the buyer as per the agreement of sale and brochure. Once that happens, then the project is complete. This is my understanding, and I feel that my understanding is not wrong. So it's already...
The gentleman was asking to gap to be reduced. That is exactly why RERA is made by government, where we are trying to protect every investor who is buying a house. So, see, the problem is not with RERA or with the government. Problem is with you. You are buying from a developer. You need to check who is the developer, how good is he has completed. You just buy from anybody and then you get caught to these situations. If we have some of the well-known builders in our city who give best of the projects. I mean, some of the builders have got awards for their projects. So all projects are all not on the same line. So you need also to decide from where to pick up the apartment and buy it. And legally, paper should be correct. What are you taking? As Rakesh Singh Saab said, completion is one part. What is the commitment by builder? That fulfilled is to be checked before you give your final payment and you take position. That's that's your responsibility. Government cannot do anything about it. We did RERA so that the fund is not taken away somewhere else and the public is not cheated. So this is another issue where you need to do a little more hard work on that. Government cannot do anything about these things.
Could I answer, or is there any gap left?
As owners, we are not competent to check whether electrical connections in the building is okay. We are not competent to check whether effluent treatment is planned. We are not competent to check whether lifts are okay. So why can't there be something to give that closure policy, what you said?
That's what I said, that as when presently...
Sir, before you answer that, I think somebody had a question regarding fire as well. You wanted to ask almost the same question. What was yours?
Yeah, hi. Mr. Harris, very nice to hear you and all of that, and Mr. Rakesh as well. So I'm part of an apartment here on Lavelle Road, and we have a lot of senior citizens. The apartment is very old. Structurally, it's very weak. It's almost 30 years old, and we're trying to go for redevelopment, but we've approached Prestige and Brigade and all of them, so they're saying that we cannot do high-rise because, we don't have that width. The entrance to the apartment, the width is less than 12 meters. So I'm wondering if with the new law that is coming up, whether we'll be able to get the fire permission. We've met with the Deputy General of Police as well, and also the fire department, but they're saying that this rule is very strict with the, NBC, the new building code. 12 meters is required, so they're not allowing.
So the law says you get high-rise when your approach road is wider. So there's a limitations to what height we can give, because when you make a high-rise, so many more apartments, so many more vehicles coming in. As it is, Bangalore traffic block is there. So we give somebody, then that road width should be allowing more vehicle to come in. So that is a rule which is there, and it is in favor of you. It is not in favor of government. It is in favor of public. So if we all have to follow it, we can live more happily. I just stay, if I walk, it takes 8 minutes to reach my house. I took 30 minutes to reach here. That's it. So we need to understand how it is.
Mr. Rakesh, yes.
To answer you, that is what I was saying. We are trying to, not trying, RERA has already completed the work. We are trying to bring that closure policy which goes beyond OC, and it addresses all the aspects of lift, permanent power supply, water supply, if it is not from BWSSB, what is the situation, and all the amenities that has been promised in the agreement to sell and the brochure.
Whatever is put in the brochure should be delivered.
Excuse me, sir. What you said, if on a piece of paper, you can give the location of your property, number of units and area at a personal, before I leave.
This is in my constituency, sir. I know that issue.
At a personal level, what they...
No, the road with entrance is small.
No, then the I'm just like that I'm answering. Now the number of units is X. The total coverage is N square meters. Now those number of units have to be fitted as per the BDA or the BBMP regulations of road width and fire safety. What best can be done, we'll try to give you a solution.
Some of the top builders are involved in that property. They are backing out because the FSA is not permitting. मुझे मालूम नहीं, उसमें opportunity नहीं है, road नहीं है ना, approach नहीं तो आप और हम नहीं दे सकते. It's a practical problem. So I think we'll close. Questions will keep coming otherwise.
Correct.
Last one question and we'll close.
I will go with the lady out here.
Please take an important subject. That's the last one.
I would like to address garbage collection, which is a major problem in our Wathu Road. I'm the president of the Prestige Greenwood Apartments on Wathu Road. Now, over a period of time, we have from the by-lanes, people taking their garbage and bringing it and dumping it in front of our apartment. We as an apartment have recycling, we have managed our garbage collection inside, and we have kept a cleanliness over the footpath, everything. But the people from the village in the Nagavarapalaya, they come out and dump it on nothing. So every morning my job is take a photograph of that, send it to the supervisor and say, please collect the garbage. And then what happens is there is a holiday, there is no collection. The truck broke down, there's no collection. The driver is sick, no collection. The driver, somebody's died, no collection. So my problem here is, when will Bangalore have a more effective garbage collection?
No, the government is already on the job. We are trying to get a new policy on garbage and new tender is being called. The old contractors have gone to the court and taken a stay on that. The government, our chief minister, who was deputy chief minister till now and in charge Bangalore city, has been put lot of effort to resolve this. So the court has intervened. The earlier contractors gone and taken a stay. We have recently, just maybe 10 days back, we had a meeting and we are trying to resolve that. I'm sure I understand your problem. We are at it. We'll try to resolve that issue, madam. Okay, thank you.
Thank you.
So I think questions will be there. Last question. If it is an important one. Yeah. Okay, one last question.
Guys, it has to revolve around housing. A very pressing issue. Somebody has something pressing, not just a general query. You have a problem, it's very, very pressing. You came only for this. You came only for this? Okay. But guys, before I do that, I think we should encourage Shri N.A. Harris and Mr. Rakesh. They've been bold enough to come and commit certain things. It's very rare to see that.
Thank you very much. I have a question. In a larger project of about more than 30 acres, where the construction happens on the different phases, so RERA is getting allocated on tower-wise. Suppose in a larger project size, when they have 10 towers, RERA happens for 10 towers differently. Is there any protocols for RERA to check whether these guys have completed the previous project at the committed timelines and committed specifications? Because we have been observing that RERA is getting sanctioned for new buildings without checking whether they have completed the previous towers. So just wanted to understand on this. Thank you.
Presently, the RERA Act doesn't answer this question. What you are asking, that the track record of the builder, when his one project is already delayed or lapsed, his next project either should not be registered. Is my understanding correct?
No, it is one project.
In one project.
You have it is under you. It is one project. He is talking about different towers.
So he has taken RERA registration for 2 towers.
It's really a master plan sanction for the entire area.
Sir, sanction is one for entire 10, for one project, 10 towers. Okay. No, one RERA approval.
No, it can't be 10 different RERA. See, 1 minute. Sir, can I intervene?
Phase development you are saying.
But so, plan will be one. One master plan.
No, so what they do, for example, they have the total project of 10 towers. They took RERA approval initially for 2 towers. Right? They did not complete those 2 towers in the given time frame, and they again went to RERA and for proposal for 2 additional towers. You are very right. Each as on today, each registration or each project, because this 2 tower becomes one project, because it's called phase development. So this becomes one project. When we sanction the second project, that is Tower 3 and Tower 4, we don't take into, as on today, we don't take into consideration the progress of Tower 1 and 2. Because the delay of Tower 1 and 2 is to be handled separately. There is a separate protocol how the delay has to be handled. But for that purpose, the present Act does not debar the promoter to get fresh sanction for Tower 3, 4 once, second time Tower 5 and 6, another time, that we don't have.
So it's a master plan sanction and the RERA's condition limits to whatever thing they take permission.
This not be done unless he has effectively done that.
Completed the first project. What's our responsibility? Department manages government by themselves. Her problem is created by the third party. He brings and puts it in front of her gate. No. So this is where the coexistence should come. We have to understand, sometimes we need to do, see, government is doing its best to clear all these things. As she rightly said, one day the auto won't come, one day the driver won't be there, one day the sweeper won't be there. See, these are all not anything which is not happening, it's there every day. I know in my constituency, I also face all these issues. But the best way is we all need to get together. Now, as an association of Bangalore Apartment Owners Association, Federation, I thank you for giving this opportunity to me. And Mr. Rakesh Singh, as a government, we are always open and ready to work for you. We are there to take your suggestions and try to make it better for everyone. Thank you. Jai Hind, Jai Karnataka.
Wow, give them a big round of applause, ladies and gentlemen. My apologies, I could not make everybody ask the question, just not practical. But coming to Shri N.A. Harris and Shri Rakesh Singh, they could have just come out here, given you a lecture and walked out. But they stood out here and they answered your question. If I were you, I would stand up and clap for them. We need more proactive leaders. Can we all give them a standing ovation? We need leaders who are accountable, who would answer to you, who would say, ask me, tell me your problems. Give a big, big, big round of applause. Ladies and gentlemen, thank you so much. Thank you for being kind. Please remain seated. Now comes one of the most important discourses, one of the most important keynotes of today. By the way, some of you who could not ask questions, you could always consult Advocate Bina Pillai's office and NLS Legal Aid Society. You could email us. We'll make sure your queries go to the right department. On that note, ladies and gentlemen, a bunch of keys was misplaced on the table outside. If they happen to have money inside the locker, give the keys to me or go and collect it. Once again, somebody lost keys, collect it outside. Ladies and gentlemen, let's move on. It is my distinct honor to introduce our keynote speaker for Proprietas 2026, Advocate Bina Pillai. Yes, ladies and gentlemen, she deserves your respect. With over 27 years of experience in the legal profession, Advocate Beena Pillai is widely recognized as one of Karnataka's leading experts in real estate and apartment law. As the founder of Next Legal Services and NLS Legal Aid Society, she successfully represented numerous apartment owners associations, homeowners, and developers in complex legal and regulatory matters. Known for her expertise in apartment governance, associate formation, the Karnataka Apartment Ownership Act, and the real estate dispute resolution, she's played a significant role in promoting legal awareness among apartment communities across the state. A champion of women's rights and access to justice, she is also the recipient of the Service Excellence in Apartment and Real Estate Law Award, the Times Power Women Conclave and Awards 2026. Ladies and gentlemen, please join me in extending a warm welcome to our keynote speaker, Advocate Beena Pillai. Let's get a big round of applause. Welcome, Beena.
Thank you so much, Shabir. Good evening to all. Good evening, Sri N.A. Harris. Good evening to Mr. Rakesh Singh, the RERA chairman, Satish Malya, my dear friend Al-Rafiq Moideen, and good evening to you all. Thank you so much for coming here. The term proprietas, you know the meaning of proprietas? Know your property. You have to have some basic understanding about the apartment law. That is the reason we have started this initiative. 2 years ago, we had Proprietas number 1, in which we have covered the apartment owner's rights and a lot of things, obligations of the builder. Probably some of, you might have appeared for that. Now, there is a serious issue which is going on in the apartment. In the sense, as our RERA chairman has mentioned, once the project is completed, there is a huge vacuum, according to me. We have real regulations till that time. We have RERA regulations, we have planning authorities rules, we have BDA rules, we have a lot of things. But after the completion of the project, what happens? The builders, to whom the builder has to hand over the project, as Madam has pointed out, many people are not paying the maintenance. What should we do? I have a client, in that it's a joint development agreement, where the developers share around 100 units are there. Builder has completed the project, occupancy is done, builder has also formed an association. But this 100 units, he kept it in his hand and he is not ready to pay the maintenance. What can we do? These kinds of issues are there in every apartment. So, because I know that this is a very boring subject, a small example I want to show, and on that basis I wanted to explain everything related to apartment law. The snake in the parking lot. See, a big cobra. It was there in the parking lot. It was hidden in unused, materials which was dumped in the parking lot. Can you show that slide? The second slide which is showing. Yes. This car parking area, the owner has dumped all these materials. A snake took shelter under that. A resident died. Who is responsible for that? Can you tell me who is responsible? Resident only? Builder has moved out of the property. You cannot blame the builder. Then, association is also there. Why? Association is the custodian of the property. Custodian in the sense they have an obligation to maintain and manage the property. So if the association is not maintaining the property, a kind of liability, we can call it as either vicarious liability or some other tortious liability, like, we can sue the builder the association against the civil negligence as well as criminal negligence. Here a person died. So both these are there. So what I am trying to say in the sense, this program we are focusing about the association governance, association formation. The million-dollar question here is under which statute we have to form an association, even though we have a specific statute, that is Karnataka Apartment Ownership Act. There are many societies which is formed under the Societies Registration Act. Okay. Under the Societies Registration Act, and there are many societies under the Karnataka Cooperative Societies Act. The objectives of these two, just carefully listen to these points. The objectives of these two statutes are totally different. Every statute has an objective clause. PF, for example, PF Act, it has an objective clause. It is meant for Provident Fund. Companies Act, it is dealing with companies. Likewise, Societies Act, it deals with what? Charitable, scientific and literary societies. You cannot form an association for maintaining and managing a property under the Societies Registration Act. The court has cancelled many societies. Even then, unfortunately, the societies registrar continued to register the societies. Now, there is a direction to the societies registrar, a collective direction not to register any apartment owners association under the Societies Registration Act. You can form an NGO under that. Okay. Then, the second one is what? Cooperative Societies Act. I'll stop for a moment. Oh, okay, sorry. The second one is the Cooperative Societies Act. You know that the objective of cooperative society is to promote the cooperative movement in this country. Your property is a private property. You are paying money to the builder. The builder, whoever it is, now Brigade is here, I can give an example. You are paying directly the money to the builder. There is no subsidy from the government, you are paying tax and you are paying a lot of things, right? So purely it is a private property, there is no need of bringing any cooperative societies, because the purpose behind the cooperative society is to promote this cooperative movement as well as for public purpose. In a private property, there is no need of bringing any cooperative society. I have seen many cooperative societies bylaw. There is an objective clause in that bylaw which says that the property in the sense the project, the entire project land has to be conveyed in favor of the society. Then who you will be? Your property is transferring to a cooperative society. This cooperative society has a special entity. It is considered as a separate person sitting next to you. So if you transfer your property to the cooperative society, what will happen? Your right over the property will be gone, and the cooperative society will become the owner of your property. There was a direction to one of the project builder to transfer the project land to the cooperative society. Then the builder said, I will cancel the sale deeds, whatever I have executed in favor of my apartment owners. Because I cannot simultaneously transfer, simultaneously convey the property or the project to same persons. I mean, at the parallelly to two different entities. One is to an individual and the other one is to a cooperative society. So these kinds of issues are happening here. The code has clearly mentioned that in an apartment, you have to form an association under the Karnataka Apartment Ownership Act. If you are very much interested, I can give you the citation also, Writ Appeal 564/2024. In a residential apartment, you have to form an association under the Karnataka Apartment Ownership Act because it is a specific statute dealing with your property. In the Cooperative Societies Act or in the Societies Act, you cannot find out any clauses, any provisions dealing with the property. This is one point which I wanted to tell. And the second point is related to UDS. There is a misconception going on here. The project land has to be conveyed to the association. You are getting UDS along with the unit. You are not only getting a building or an apartment unit because it is constructed on the land, it is not on air. So the builder will be giving you a small piece of land proportionate to what? The built-up area which you are entitled. So you are getting the apartment unit along with the piece of land. That piece of land is the undivided share. So there is not even an inch left after the project is completed for the developer to convey to any other person or convey to any other association. So please don't approach the court or to RERA or wherever it is saying that my project land is still with the landowner or with the builder. It has to be transferred to the association. It is a misconception. Your land is with you. That land is given to you by the builder in small pieces. It is known as UDS. The difference between an independent property and that piece of land is that it cannot be divided. Because, as I'm just borrowing from Mr. N.A. Harris, it is a collective unit which everyone is jointly owning, right? So that concept we have to see. The second proprietas I thought of, calling with this particular important issue. Everyone is coming and saying that my land is not conveyed. My land is not given to the association after having a sale deed in their hand. If you just check it in your sale deed, last page, there is a schedule of the property. The first schedule will be Schedule A. Schedule A contains the entire project land. Schedule B is your undivided share, probably in percentage wise or square feet basis. And Schedule C is your apartment. So this is one thing which I want to tell you. Please don't do that. Don't convey any of your project land to cooperative societies or any other societies. We have a specific statute, that is Karnataka Apartment Ownership Act. Please go ahead with forming an association under Karnataka Apartment Ownership Act. In the Google form, we have also asked people to send some queries. The most of the queries we have received related to Apartment Owners Association. As he has pointed out, if you have a proper association with a proper bylaw, bylaw is the constitution, that is the main document where it prescribes the rules and regulations of that particular apartment complex. You have to follow that. There is absolutely nothing, ambiguous here. Bylaw says that, you have to keep a CCTV, keep a CCTV. In case if the bylaw says and you don't have a CCTV, what happens? If any theft happens, then the association will be responsible. The snake example, we can go back to that example. In that example, as I said, if the resident died by getting a snake bite, the association is responsible. If someone is drowned in a swimming pool, vicariously it will come back. Because of the negligence of the association, if anything happens, they will be responsible. There are fire and safety equipment, if it is sold, who will be responsible? Finally, the responsibility comes back to the association. So how the associations can overcome all these things? They can be vigilant. They have to follow certain things. They have to ensure that systems are working proper. If any financial issue is there, who will be responsible ultimately? The apartment owners. The Apartment Owners Association. How to overcome that? You have to have a system for proper auditing. And if you have done all these things and any mishap happened, the presumption is that it is not yours. It is the act of God. You are safe. In one of my clients' apartment, the lift fell down. There is a rope or something which is connecting the lift, right? So that one is broken. The person is crushed inside the lift and he's paralyzed. Who is responsible? The police came and registered FIR against the apartment owners. Fortunately, they have a proper association. They have formed under the Karnataka Apartment Ownership Act 1972. Just imagine if it is a society, then your association is also not legal. Then what happens? Every individuals who is inside that committee, they will be personally liable for this. So be conscious about all these things. And you have to have a proper body for maintaining and managing the association. Just custody of the property, when you take it, there are a lot of responsibilities are coming to you that the association has to understand. Otherwise, the civil negligence as well as criminal negligence will pop up. See, this vacuum I said, right, project completion, we have regulations. After the project completion, what happens? We have only one specific statute which says that you can form an association. And according to me, many people are saying that the Karnataka Apartment Ownership Act is not a good act, or there are loopholes or something. But I don't agree with that. It's a 50-year-old act. One competent authority is not appointed by the government. That doesn't mean that the act is weak. According to me, competent authority is not required. If a competent authority is there, your job will be double. First, you have to go to them. Then only you can come back to court. So if you directly go to High Court will say that no, there are certain alternative mechanism. Why can't you go there? Then come back. They will take another 2 years. So these will be delayed. Then one other problems which people are pointing out, that there is no registration certificate. Do you have a registration certificate when you purchase the property? Do you have a registration certificate which says that you are the owner of apartment number 101? How will you find out that? Your sale deed, on the back side, there is an endorsement from the registrar. It says that this particular property is registered in your name. That number you will be using as what? Your registration number of the property. Likewise, under the Karnataka Apartment Ownership Act, there is a document called Deed of Declaration. Since it is connected to the property, the makers of statute, according to me, very carefully thought about this and made it as a mandatory document to be registered before the sub-registrar, the property registrar. And this deed of declaration is a collective document stating about the property, the entire project. Your sale deed is only talking about what? Your property. But this deed of declaration is describing about the entire project. So you can take it as a reference point, right? And the Karnataka Apartment Ownership Act. There are provisions for bylaw. Bylaw, how to draft a bylaw? What are the provisions to be included in the bylaw? What is proxy? What is quorum? People are coming and asking questions even in the Google form also, a lot of things are there. But, you know, the statute is very clear. Section 16, if you read it, you can understand that. How to draft a bylaw? Probably a little weaker one. You can strengthen it. A format is also being given. So, statutes are there. People are not utilizing it. They are just going ahead with something else without having basic knowledge about the property. The property is the one which you are investing more, right? It is the biggest investment in your life. For an apartment, you will be investing around 2 crore, 3 crore or whatever it is. And if you are not aware of the basic laws related to apartment or property, I think it is time for you to have a little knowledge. I'm not saying that the entire things you have to study, as he pointed out. I will be jobless. But the basic things at least, people are coming here by saying that, you know, the sale agreement is there. What is the need of sale deed? They are not understanding the difference between sale agreement, sale deed. What is UDS? What is occupancy certificate? What is the importance of occupancy certificate? What is khata? People are thinking that khata is the title document. It is not the title document. Your sale deed is your parent document. Okay, the sale deed says that you are the owner of the property. If there is any delay in that, then you have to be worried about that. Okay, so the general things, it is time for us to sit together and to understand it. We have learned a lot about sin theta, cos theta and all those things in schools. But unfortunately, you know, we didn't get a chance to learn constitution or the basic laws. I think it has to be considered by the government. Okay. So these are some basic things. I know that this is a very boring subject. If you have any questions or anything, see, one point which I wanted to emphasize, I repeat it again, that your negligence, then the vicarious liability. Vicarious liability says that master is responsible for the servants thing. That is a usual word they are using. It's an old concept. This vicarious liability, when it comes, you are an interesting facilitator or a security agency. And that security agency has certain responsibilities. He has a responsibility to pay the Minimum Wages Act. He has a responsibility to pay the PF. He has a responsibility to pay the ESI. And the Post Act, if more than, 10 female employees are there. All these are his responsibility. And in case if he is not doing this, who will be responsible? Association. Association means who? You all together are the association. This is another misconception. Association doesn't mean that the executive committee members. Association means you all together. Karnataka Apartment Ownership Act has very beautifully mentioned that. Association means all the apartment owners join together. And certain people taking responsibility on a particular time period is the executive committee. And this executive committee has to act on the basis of bylaw. Bylaw is a Bible where they can refer. If the bylaw has to be amended, the general body, you can call it. And the general body is the supreme body, not your executive committee. If the general body says no, you can't do anything. If the general body says yes, with majority, you can go ahead. Okay. So if any doubts or anything, we can, go ahead with that. Many people have sent in Google form. Huh. So from one apartment, they are asking BWSSB related issues. The BWSSB chairman has had agreed to come, but I think some reconstitution happened after the, that recently. So because of that, I think the chairman itself is changed. So he didn't come. I'm so sorry for that. We can coordinate with them again. So his doubt in the sense, they had already paid for the entire phase. Like someone has pointed out that, there are 10 towers and 2-3 towers were not completed. In this apartment also, these were the issue. 2-3 towers were not completed. Sorry, I think I can continue. I'm so sorry. I know that your time is very precious. Okay, I'm just explaining to them. Thank you. So in this, what happened in the sense,
This session is in progress. It is considered to be very disrespectful. Kindly remain seated. Thank you so much. The session is in progress. Ma'am.
Okay. So now you got a very good interaction with Mr. N.A. Harris and the chairman of RERA. Even they have also promised that, they are ready to sit with you. Probably we can coordinate for, getting some answers from them directly without much introduction. I know that you will be very impatient. Then this particular issue, actually, just imagine there are, as per the plan, 10 towers. When 7 towers were completed, then BWSSB connection is given. Then another 2 towers on progress. But the BW department came and disconnected by saying that the deposit towards the other 2 towers were not paid. So ultimately, the BWSSB department has removed the connection. They had made the payment to the builder. The builder has paid a portion of it. That's what I believe. See, this one important thing in the sense, these kind of connections, they need not have to pay it in advance. It will come in stage-wise. 30% initially, 60% initially. The second phase, like that. Probably the builder might have given the 2 installments, the next installments they might not have paid. In such situation, BWSSB or BESCOM or whoever it is, they will come and disconnect it. So here also, that is what happened. Now, water is the basic amenity. You know that we need water. So without water, now they are struggling. What should we do? They are depending on some commercial options. No water connection. Can we address the issue? That is what they are asking. The only option in front of me is to approach the court. We have guided them. We will guide them. And one thing which you have to take it from this in the sense, the Karnataka Ownership Flats Regulation Act as well as RERA says that if you pay for BWSSB, the builder has to deposit this to an account which is created for BWSSB. He cannot utilize this fund for something else and come back by saying that you don't have this. So this is the only thing which you can take it from here. And the only option in front of us, this particular client, is to approach the court. Probably we can also coordinate with the BWSSB department and to get some solution for that. Yeah, is there any other queries? A lot of queries were there. All those things were connected with association formation, please. So I think almost I had also included. Please, sir.
Yes. She's pointed out to you. You could step forward, collect the mic from my hands, and you could ask your question.
Hi, ma'am. Good evening.
Good evening.
So, I am from Shobha Forest View. I am the Vice President of the Management Committee there. With all due respect to the KOA Act, the one problem which we are facing is that a lot of residents are questioning the competency and authenticity of the KOA Act. A lot of litigants, as per legal term, have come on to saying that, yeah, please show the registration certificate. Even if it's KOA, is it the right competent authority? That's question number one. They have approached the court, and as you rightly pointed out, if there are so many mechanisms in place already, then why is the court accepting the cases? We have so many acts which is actually in favor of the right resident or the correct behavioral resident, but then if you're following everything, then still there are cases on us. So I'm not able to understand if KOA is the right act or not. If it is, then I can go back to my general body and say that, hey, our society is registered correctly. But I think we are facing a lot. I don't know if this problem is faced by others, but this is becoming a regular notion in our society at least. So I wanted to hear your thoughts on that.
This issue can be resolved by the government with a single notification. That is what I believe. They have enacted a statute. They are the one who has enacted. For every statute enactment, a lot of money is also required. Then, in the statute, it is very clearly mentioned that it is a specific beneficial statute for apartment. We don't have any other statute for apartments in Karnataka, at least I can say. So when you have a statute, that is what I said, that example of Provident Fund or company, you cannot go and register your company under some other act.
No, it's under KOA only because
I'm just saying that. I'm just giving you an example. What is the difference between a specific statute and a general statute?
Right.
Specific statute is for that specific purposes which is mentioned in the act. What is the specific purpose mentioned in the act? The act has provided a lot of things related to apartment maintenance, how to maintain the apartment, how to manage the apartment, how your bylaw should be drafted. Everything is mentioned in that act. So people are not following it and they are thinking that the registration certificate is the biggest one. That is the reason I told you. Do you have a registration certificate which says that your apartment is such and such?
Yes.
You don't have. Do you have that? This is my apartment's registration certificate. But your apartment is registered. What is the evidence of that? On the sale deed, if you check it on the back side, there is an endorsement from the registering authority with a number. So section 60 of the Registration Act has mentioned that when the registration is complete, when this endorsement is given, the registration is complete. There is no need of a certificate. If I can give you one other example. Do you have a certificate saying that, what is your name?
Deepak.
Deepak. Do you have a certificate saying that your name is Deepak?
I do. I have a lot of certificates.
A lot of connected things are there. Yeah. Birth certificate, what is the importance? Your birth date, not your name.
Yeah.
Your passport, what's the importance?
Nationality.
Yes, you are the citizen of India or wherever it is. Now the Aadhaar card is a recognized identity, but you don't have a certificate which specifically says that I certify that this is Mr. Rakesh, etc. It is not there. So registration certificate is not the biggest thing. Whether it is registered or not.
It is.
Registration means endorsement by the registering authority. The Act has mentioned that who is the registering authority? It is the Property Registrar, Section 13. See, the Act has clearly mentioned all this. How to register, where to register, how to draft it. How many statutes are like that with a model bylaw also? But even then, there are certain, advocates of cooperative society, and I'm so sorry to say that we can see maximum corruption in cooperative societies. Am I right? Wherever you have taken, I'm from Kerala, this urban banks and, even in Karnataka, crores of, because only 20 members are required for creating a cooperative society. Now there are huge townships. Just imagine 20 random members. They just created a cooperative society with an objective of seeing that the project land has to be conveyed to them.
Right.
What happens? The word conveys, the meaning of that sale. People are randomly using it. Convey, deemed conveyance, a lot of things. So that is what I'm saying.
Yeah.
Once you get your sale deed in your favor, you are safe.
Yeah.
You are the owner of that property. The next thing is what? It's a collective ownership. For that we need someone for maintaining the property.
True.
Right? A karta or whatever we can call in the joint family. Just imagine, hypothetically I'm saying, this karta is the committee. But in that family, we all should be a member. Right? My property is also there. So I should also be a member.
Right.
Random 20 members cannot create a cooperative society and ask me to follow their rules and regulations where there are no rules and regulations related to the properties.
But in reality,
Yeah.
that's happening, ma'am. And the problem is that
I understood.
And the problem is we are not able to put punitive action because they have a high court order. So I know. I don't want to make it conversational, but the larger problem statement which I wanted to highlight is we have an act, it is enforced, it is registered, but still there are loopholes, and because of 20-25 individuals, 850 residents have to suffer. That's a larger point I just wanted to land with you, and just a little bit on the lighter side. If you can have a lot of people in your team to visit societies and educate them, I think it will be doing wonders. Because people have to be educated on this to make an act. Because we have, sorry to use that word, a lot of unparliamentary people coming into apartment associations, and they pass a bylaw which eats up the society for years to come. That is the major problem. So I think the awareness training program to educate people, youngsters coming in, I'm happy to join the MC. I'm 30 years old. People should come in, volunteer, and it's not a thankless job. It's a commitment I'm making for 2 years. I want to live in that society and give my kid the best facilities that way. So I feel that should be the messaging that I think from your team should land. Thank you so much.
Definitely, yeah. Okay, so you can write your questions. Can we take a short break? They have some plans for that, so that We'll be taking it for 2 minutes.
Ladies and gentlemen, we'll take a short break and we'll come back after the break for the Q&A.
I'll come back.
Thank you so much. A big round of applause. Advocate Beena Pillai. Ladies and gentlemen, it is our honor, it is our privilege, and we'd like to acknowledge Mr. Vishwa Pratap Desu. Ladies and gentlemen, he's the CEO, Residential Brigade Group. Give him a big round of applause. Thank you so much for being out here, for encouraging us, and for making this happen. He's a seasoned marketing and sales professional with a total of 37 years experience, out of which 29 years plus has been in the real estate in India, Mumbai, South India. Currently he's based in Bangalore with a real estate developer, which is of course Brigade, handling multi-domain sales, manages the entire spectrum of real estate marketing and CRM activity for them. Ladies and gentlemen, once again, give a big round of applause. He is adjudged as one of the top CMOs in the real estate sector, recognized by ET now. Thank you so much, sir. All right, ladies and gentlemen, very important announcement for people who are walking away. This is not over. Advocate Beena Pillai will answer more of your questions. Meanwhile, we have a dance performance coming up by the students of St. Joseph's Law College. Let's have a cultural interlude. Give them a big round of applause. Thank you so much. Welcome them on stage.
बिलुरी कहत है ऋतु राजा आयो कहत है ऋतु राजा आयो कहत है ऋतु राजा आयो रे मम बनी मम बनी भरी मम मनी पा रे रे मम बनी मनी रे रे मम बनी रे मम बनी रे मम बनी रे 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 मनी मम रे रे मम बनी रे मम बनी रे मम बनी रे 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 मनी मम रे 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 मम बनी रे मम बनी रे मम बनी रे 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 मनी मम रे गरज आज में घनन घनन गायो रे धमक धमक चमके बिलुरी कहत है ऋतु राजा आयो रे
Ladies and gentlemen, Advocate Beena Pillai is out here. Give her a big round of applause. She's been very kind enough. So after the vote of thanks, you could meet her one-to-one. You could sit on that sofa and you could ask that query. In the interest of time, ladies and gentlemen, it's time to conclude this event. And to deliver the vote of thanks, put your hands together, ladies and gentlemen, for Advocate Nida from NLS Legal Aid Society. Give her a big round of applause. She'll be delivering the vote of thanks. Once again, if you have any questions, you could do a one-to-one. Check. People who are waiting to do one-to-one, let's wait for the vote of thanks. Post the vote of thanks. You could. I love the way you're all sitting around her like that. Thank you. Over to you, Nida.
Good evening, everyone. As we have come to the close of an enlightening and enriching day, it is my privilege to propose the vote of thanks on behalf of the members of the NLS Legal Aid Society. I would like to begin by thanking all the distinguished guests for taking the time to be with us today. We extend our sincere appreciation to Justice Ashok B. Hinjagiri, Chairman, Law Commission Karnataka, and former Justice of the Karnataka High Court for sharing his insights. Our heartfelt thanks also goes to Sri Rakesh Singh, retired IAS, Chairman of Karnataka RERA, for providing their valuable insights. We are equally grateful to Sri N.A. Harris, Chairman of Bangalore Development Authority, for sharing his perspectives on urban development and housing. We also thank retired Judge K. Ramchandran for joining us and contributing to our discussions today. We would also like to thank Advocate Beena Pillai, whose expertise and practical guidance helps translate complex legal principle into knowledge that can be applied. A special word of appreciation to Sri Rajendra Kumar Kataria, IAS, for sharing his time, experience, and perspectives with us. I would also like to thank Sri Ramesh Padmanabhan, Governing Council, BAF, for his insights. My sincere thanks to our moderator, Mr. Shabir, and also the volunteers, organizing committee members, technical team, hospitality team, and every individual who worked diligently behind the scenes. Events such as this are made possible by the dedication of many people whose contributions are often remain unseen. I would also like to acknowledge our performers for their cultural presentation, for adding a special touch to the event. Our gratitude also extends to Sri Pauline Priya, the principal of St. Joseph's Law College, for hosting us, and also to Prime Events and Mr. Ranjit for their coordination, and to our technical team for ensuring the program proceeds smoothly. I would also like to thank press and media for joining us today and for helping carry these conversations beyond this venue. Most importantly, I would like to thank all our participants, apartment owners, apartment association members, lawyers, students, and members of the public. Your engagement and participation are what made Proprietas 2026 fruitful. As we leave today, I hope we carry forward not only the knowledge we have gained, but also a renewed commitment to responsible property ownership. Thank you once again for being a part of Proprietas 2026. I wish a pleasant evening and enjoyable dinner ahead. Thank you.
Thank you so much, Advocate Nida. Ladies and gentlemen, I'd like to welcome back Advocate Beena Pillai for her concluding remarks. Ladies and gentlemen, a big round of applause. Welcome her back.
See, before starting this question and answer session, I just wanted to say 2 words about SBM. You might have seen that SBM stall outside. It is an attempt of sexually abused survivors of that. My humble request to all of you, If there is an opportunity for you to buy anything from them, they are trying to, survive with sewing machines. Please do something for them, and we will share you their website in case if you are not able to buy something from here, okay? And Brigade project is related to senior citizenship. If anyone is interested, please. Thank you so much. I'll come back to you. I want to sit with you, and then we can discuss.
All right, lady.
Sorry. No, you can sit. No, it's okay. I can stand. Broadly, how many stages are there in obtaining OC? You don't have to go through compliance and other things. How many stages of approval, and who is the corresponding approval authority if it is under Bayappa and Panchayat, Gram Panchayat? They are not a Gram Panchayat.
Yeah, you're talking about the project approvals, right? You're down. Oh, okay. See, CC means, commencement certificate, right? Oh, you're referring completion certificate. See, the completion certificate is actually, no, completion certificate from whom you have obtained? Okay. See, commencement certificate is for at the time of commencing the project. I'll tell you, I'll come to that. There are 2-3 things which I wanted to explain. Commencement certificate, the developer has to obtain, after this columns, foundations and all those things. So it is ready for commencement. You can consider in that way. Then, after the commencement certificate, then the next one comes, what is that? Occupancy certificate after the project is completed. Without commencement certificate, the chances of getting an occupancy certificate is very less. You are talking about the planning authority. So you said the completion certificate is received. Now your problem is occupancy is not received. Occupancy, there is a lot of delay in all the project. I don't know whether I can say it loudly, because lot of money is required for getting an occupancy certificate. Many of the builders are not able to procure that. So probably, what I am thinking in the sense, like this we can also have a group discussion. I can try to invite government officials also in this. Unfortunately, because of the internal reconstitution of the ministry, as I said, BWSSP chairman, he changed yesterday. Those kind of things are happening here. So once at the right time, we can have a discussion. OC is a very important thing. Without OC, you may not be able to, obtain khata. Registration, the law says that without getting occupancy, as I said, no, what is the meaning of occupancy certificate? The project is safe to occupy. Project is ready to occupy. The project is safe to occupy. So the law says that you should not occupy a building without getting an occupancy certificate. But if I say that you should not go and occupy the building, you are the one only losing the money, right? EMI is there, then you will have to pay additionally rent somewhere else. Lot of things will be there. So the practical solution is you can possess the property. This is not the legal solution. A practical solution, you can possess the property, occupy the property. No, without occupancy certificate. It was possible, now it is not possible. You got clarity on this? Okay, fine. Yeah. Please. No, this OC, I think DKS has also mentioned certain things yesterday related to OC and Khata and regularization of the properties. Probably, we all have to go and meet him. Everyone has to, we gather together. This proprietors, what we can do, through proprietors, we will communicate to you. So these kind of sessions, if people goes together, they will also be interested. Like N.A. Harris has mentioned, RERA chairman. With RERA chairman, we can also have some discussions. With the different departments, we can also have certain, discussions. We have to create a group. That is what I wanted to say. Please, ma'am.
So my name is Shachi Pathak. I am a social media manager of a lot of groups in Bangalore and a lot of groups, Facebook, WhatsApp and a lot of things. So it's like a lot of questions come around these and I'm like surprised many don't even know the basic things. So I was going to in fact request you the same thing, like can we have some education sessions or some newsletter or some channels where people get to know starting with basic, maybe probably then they can reach out to you for the queries further. But the basic education is something which is the need of the time because this act has come in place. And many even don't know, I mean, there are many with the society registration, still with that act. So I guess you can probably, the group thing, please, I have sent you a message on your phone. And if you create a group, please add all of us.
Hello.
I'm also so interested to, be with you guys. And if I can do something for rectifying these, definitely I'll do that. Now you all have our details, right? You might have got it from the registration desk. Please communicate to us. I'll appoint someone, from my team itself.
Check.
They will coordinate with you. If you are not getting any answer from my team, please let me know. Okay? Okay, whatever it is.
Thank you
Sorry,
for...
he was asking for a long time. Yeah.
See, it's a long pending project, almost 18 years or over. 1,000 apartments are there, 10 blocks are there. 10 blocks. They are saying that, Apex will be formed only after the third stage is completed. Phase-wise development is there.
Okay.
Correct. Apex is because for common area maintenance facilities, DOD is there. That is one question, madam. One last, big.
Okay.
See, in the functioning of the association, what is happening is members are not coming forward, the owners. But according to Apartment Owners Act, I read that family members can be OBs. They have the voting rights. So these two questions we need some clarification. So that if the owners are away from the country, their family members can be allowed. That provision is there in Rule 9. Could you please elaborate?
See, we need not have to depend on the act for this. See, you can execute a power of attorney. Authorizing, that power of attorney, through the power of attorney, you can authorize a person, whatever you want to do. He can act in your shoes. They cannot reject. No one can reject, but it should be a registered power of attorney.
Okay.
See, whoever is purchasing a property, along with that, you can also execute a power of attorney. Again, I'll say that even though you are in your 30s, execute a will. That will also definitely help you. Because a lot of legal, in case if someone dies without executing a will, a headache is too much. I'll be getting work, but your headache is too much.
Correct.
Just a
Madam,
second.
that Apex formation, sir.
1 second, just hear this. We all think it is great to execute a POA. Fantastic. Please check whether the person is an Indian citizen or he has got overseas citizenship. If a person has got overseas citizenship and his name is Ravi Padmanabhan, he cannot execute a power of attorney under an Indian law. He should get it apostilled and he should get it all sorted out at their end. Please be sure about that because there should not later be a challenge that the power of attorney was not properly done. This is specifically in case of people who have taken other countries' citizenship. You can have a OCI card, but that doesn't mean that you are an Indian citizen now. The person who executes or whom it is executed? The person who gives the POA.
If he's not of Indian citizen on that date, he has to execute it as per the laws of that country.
One second, let me clarify that. See, power of attorney means what? You are authorizing someone to act on behalf of you. Okay, so if you are authorizing your blood relative, for example, who is blood relative, as per law, your siblings are blood relatives, your parents are blood relatives, your children are blood relatives. One exemption is given, your spouse. Okay, for selling the property, you have to register this power of attorney. Whoever it is, you have to register this power of attorney. But if it is related to the immobile property. Immobile property means land, property and all those things. Mobile property means your bank deposits and all. For dealing with immobile property, you have to register a power of attorney. In case, if you execute the power of attorney in favor of your blood relatives and your spouse, stamp duty will not be there. But if you register a power of attorney in favor of me, you have to pay stamp duty. If your value of the property is 3 crore, then approximately around 5%, 3 into 5%, how much? Around 15 lakh rupees you will have to spend for that. So that is the reason it is always better to register the power of attorney in favor of your blood relative. Coming to his point of apostilling the document, the law behind that particular point is, if you are executing a document outside the country, it has to be authenticated. If you are executing a document from India, it is not required. But registration is an exemption related to immobile property. But anything related to, for example, a name change. If you are executing a power of attorney from US, you have to go to apostille agencies or embassies. Embassy attestation is too difficult for you. There are agencies, because India and US and all are a part of Hague Convention. There is a convention. Based on that, you can go to certain agencies. These agencies are known as apostille agencies, APOSTILLE. So there you have to go and get it attested. Then once the document comes here, if it is related to sale of your property, then this document you have to take to the district registrar office. There it has to be again authenticated. So 2 steps is required. Okay, but what my point, his question is related to, can he appoint someone to act on behalf of him? He is the owner of the property. So execute a power of attorney. Family unit, because honor means, you have also shown me. What is the definition here?
Includes a person message.
Person includes a joint family. Okay. His form. So on a safer side, sir, my suggestion, you have to fight among your people itself. Tomorrow if any problem comes, I won't come there. If you have some cardiac issues or something, you have to call your neighbor. So my suggestion always is to don't go with argument. As you pointed out, it is correct. But it's always better to have a power of attorney in your hand and then show to him. It's not a big thing. That is one. When it comes to your Apex Federation, okay. So there are 3 association, 3 deed of declaration I understood, right? At least 3 phases. In that, every deed of declaration, the law says that bylaw should also be attached. Right? Deed of declaration is not a single document. It is annexed with bylaw. And I have pointed out earlier, it is your Bible or Gita or whatever you wanted to call. So bylaw says what exactly the rules and regulations, how to maintain and manage the property. Okay, so this
if the deed of declaration is not executed by the builder, what can be done for that? If the deed of declaration
That's a very complicated thing. So in your case, actually, builder is ready for all these things. Only thing is that an apex federation is not created, right? It's better you can talk to the builder, ask the builder to create an apex federations bylaw. Apex federation, because there are 3 associations, A, B, C associations. Huh? 10 associations. Okay, 3 or 10. There are, just imagine 3 associations or 6 associations. A plus B plus C plus D plus E is the apex federation. And this apex federation is controlling wherever it is required. So in your bylaw, there should be clarity. You should not give a lot of authority to apex federation also, because your apartment complex needs might be different. And this apex federations, what exactly they have to do? Probably the roads and common area maintenance management and a lot of things. So why the builder is not agreeing?
After the third phase is over, I told. Third phase is not yet started also.
See, big, huge apartment townships, there are practical difficulties, I do agree. But, we can talk to, we can. If the builder doesn't agree, then we can send a letter to the builder, notice to the builder. All those done. Okay, you let me know which builder, what I can do, I'll tell you. We can do that, yeah. But you are clear about what to do. Apex federation is there, bylaw is also required, you have to do. That is what RERA chairman, someone has pointed out. They have 10 towers, in that 7 is only completed. Then again the sanction is giving for another 2 without completing the third one.
Madam, can you just enlighten us on DOD, not conveying the DOD by the builder?
DOD is sorry please, yeah.
And what is the implication if it is not done, but how to do it?
Okay, so DOD is the constitutional document of the association which is registered under the Karnataka Apartment Ownership Act. The procedure I'll tell you. If you want to register an association under the Karnataka Apartment Ownership Act, DOD, Deed of Declaration, has to be drafted. What are the contents in the Deed of Declaration? It discusses about the project. This project is 5 acres of project. This has these many units. And every apartment owner is entitled or, his share is such and such, UDS. His super built up area is this. All these information will be there in the DOD. That is what I said, this DOD is a very important document. You will be getting only information about your property or apartment unit from your sale deed. You may not be getting a collective document, or you don't have a collective document which says that in this project A01 is such and such measurement, B01 is such and such, and B01 owner is entitled for 300 square feet, A01 person is. Why it is important? Because at the time of purchasing the property, you may not be having an option of verifying. Have you done any survey? Many projects I have seen that this UDS is not tallying with the available land. So I don't know what are there in this Alibaba's, whatever it is. But what I'm trying to say, UDS tallying is a very important thing. I forgot to speak about handover also. Handover is a very important thing.
But if it doesn't, the builder does not convey the DOD, what should be the...
Please don't use the word convey randomly. Convey means sale. You have to use this. You have to write in somewhere. Why you are selling your property again and again? You are the owner. If the builder is not executing, the word executing means builder is not, writing or signing that document, creating that document, what you have to do, that is what your question is. You can approach the court, you can send a legal notice to the builder. you can approach me. I have some solutions for that. We can do that. But I have a suggestion to the government also. Now the Karnataka Apartment Ownership Act says that everyone has to give consent for this. And in an apartment where 50 units, 60 units, it's practically possible. But what about an apartment with 1,000 units or 2,000 units? Before sale, it is possible. The builder can do that. Builder can easily execute a deed of declaration. But after sale means he'll have to get the consent from each and every 2,000 unit owners. It is a practically difficult thing. This is the one people have to concentrate, not about KMA and all those things. I really don't want to talk about that. That is this, government's job. My suggestions to everyone is that, this has to be amended. Yeah, you can see if all the owners are ready to come forward. If all the owners give consent, we can do that. I have done in an apartment where 1,980 units were there. It's a huge, work. But even then, people have coordinated. They have called them. All of them have.
But DOD was supposed to be, whereas it's executed by the builder to enable him to sell the apartments. But whereas owners have to execute, one second, let me just finish. Never knows that DOA, that is deed of apartment, is something that the owners have to sign up for if you have to form an association. And now currently our association, which is an illegal board, has continued for almost 3 years without conducting any election, without conducting any meetings, is now insisting on a Form B and a membership. Now, as you said, DOD clearly says that we are all members, right? So why is a Form B required and a membership fee of 1,000?
That is a procedural thing. Every statute says that in procedures.
But in the KOA Act, it is not said.
KOA Act says that
Only
there
one
are...
rupee.
No, ma'am, let me complete. So in KOA Act, there are two procedures. One is the deed of declaration, that is the parent document. The another one which is prescribed is an individual declaration.
Yeah,
Deed of declaration is a collective declaration. Yeah. Individual declaration, it is very simple that I am ready to, execute this deed of declaration. It is a consent form kind of thing. Yeah, the legal language is that I am ready to bring my apartment unit under the Karnataka Apartment Ownership Act. That's the simple thing. But what is the problem in giving?
But that's a simple thing which was said in Form B. So why was Form B not initiated by the builder when he went to register each owner's sale deed? Correct?
If the deed of declaration is already executed and the election is conducted and your body is in place, there is no need of exercising it again. But in case if they are doing it, I am not saying that it is a wrong step also.
Listen. The election was deemed illegal by one of our competent, legally qualified owners, Mrs. Bhagya Lakshmi, who is also a member of the RERA, who said, from 2016 until 2024, she has filed a case with PHL, not paying maintenance. But now because of that case, she went to Lok Adalat and got a waiver of all her MC for the last so many years. And that has affected all the owners who are paying. So how do we address this issue? Whereas this illegal board has supported her because her advocate is representing the association now to fight with the owners.
See, the answer to this is that if the deed of declaration is already been executed and if you have already conducted an election and everything is in place, there is no need of digging it again. So that is one. In case if they are going to dig it again, there is absolutely nothing wrong in executing one more Form B declaration, confirming that I am also, what is wrong? Probably some practical difficulty.
First and foremost, PHL didn't hand over a complete project. No. Yeah, broad guideline, we
No,
are
ma'am,
still suffering from-
what he is saying in the sense, we cannot club all these together. Association formation is one thing.
Yeah.
And the other things, what she has done, she has taken an advantage
Of the situation. Okay.
and very easily,
manipulate
everything,
Yes.
many
But
people.
what about electricity now for us? We are suffering because PHL has not installed that substation, 66 kV substation. Earlier they said because of this lady's litigation, they could not proceed with it. And now we are still suffering. Today we had no power the whole day.
You send me what exactly the litigation. Let me go through that because it's a very fact-based issue.
And I have escalated all these issues to PAF since 1 year. Now just now I spoke to Mr. Satish Malia also. I said I have not had any response from your team. At least somebody should be able to guide us. How do we go ahead? I'm a non-resident. So when I come here, it does really affect me a lot. Because there is no proper authority to look into. There is no one we can escalate to.
I think I would like to respond to your issue back.
Strictly speaking, we are not here to respond to public queries. We are here to respond to our members. Yes. If your members of BAF is different, you said we have not responded. That's not the case because legally, I have not seen anything on my desk which is lying around connected to your issue as on date. If you're speaking with Satish on a personal ground, then please don't come here and say that we have not responded. I think I'll take it up very seriously. It's not a fair statement. We are all doing work pro bono and we expect that decorum to be maintained. I mean, you can't come here and make these kind of loud claims. They're not responding. We have not, sorry, under any obligation to respond.
One second now. Sorry. See, this, deed of declaration, are you clear? You're clear about, I'm asking everyone, you're clear about which association, one second, you're clear about which association you have to form, how to form an association you're clear about, what you should not do also, at least that you are clear about, don't convey your land, you're the landowners. We have to take this slogan, this apartment land belongs to apartment owners. It is in a small undivided portion. Right? Okay, if you are clear about that, I think the purpose of this proprietas is served. And I'll definitely, sir. See, whatever queries ma'am is asking, deed of declaration is already been executed. According to me, 90% work is done. Right? If the builder can execute a deed of declaration in the initial stage itself, the law might have foreseen it actually. The law says that owner can bring the property. Before the sale, who is the owner? Builder is the owner. And the builder has brought the property under the act. So it is over. If there are multiple sales happened during that time when he executed the deed of declaration, just imagine he executed the deed of declaration after 50 sales are over. 50 sale deeds are executed. Then he along with this 50 apartment owners are the owners of this property. So he will have to go and get Form B declaration from every 51. But the law says that before sale also he can bring the property. That is the best thing also. You have to insist each and every builder to register under the Karnataka Apartment Ownership Act before the sale itself. If we do that, if we insist for that, all this confusion will be over. Then on appropriate time, when you are ready to get the handover, you can constitute the committee, you can conduct the election, people will be there, you will be having a bylaw. If the bylaw drafted by the builder is not good, we can go ahead with amendment and make it a stronger one. All these can be done. Please don't, waste time on some consent letters. Form B importance is only that consent. Already it is done.
While you are all eager to ask questions, all of you had dinner? Yes. My humble sister has not had anything.
No problem.
Please.
I call them for their clarifications. I am ready. Ma'am, sorry, he is waiting for
it. It's a general question, madam.
Huh.
Regarding the validity of the resolution passed in general body, and also the
One second, your association is under? No, I'm asking in your apartment, which association, under which act?
It is 1960 Act.
Huh.
One minute, I'll come to that. See, one is that.
Sir, 1 second, after.
Let me complete it.
I understood.
Mine is covers yours also. See, the validity of. So, see, my question is for the validity of resolution passed in a general body. See, the fact is that, see, I belong to GR8 where 248 flats are there. So
340.
248. Okay. And whenever we call for a general body, only some 50 people, 30 to 50 people will turn up. So whether the resolutions which we are taking there, whether it is valid or not.
Okay.
Yeah? Number one. No. Okay, sir, let me complete first.
Okay, I understood. I understood that question.
I am all the way over here to ask her, not to you.
No, sir, please. Sir, please. Yeah.
So this is the one point. The second is, see.
Can I answer to this and then?
You give to everybody, sir.
No, can I answer to this particular question? And then, see, he asked a question and he's also pointing out that quorum is not there. Okay, so what happened here? 248 units. Association is not valid, that I can say 1960. Forget about that. Just imagine it is a 1972 association, a valid association. They called for a general body meeting. They have sent communications to each and everyone. 248 received it. Only 15 has turned up. Whose fault is that? Is it committee's fault or your fault? You are not interested to go there. It is your responsibility to go and attend the meeting. If you are a responsible apartment owner. In your sale deed also there are a lot of clauses which mentions this. Right? You are not going there and you are saying that only 15 has attended the meeting. They passed resolution. How can you say that it is unilateral? Correct. Yeah. The legal answer is in the sense you didn't go and...
Act is bringing something to validate. Like I'm a finance professional, whatever decisions, complaints like MCA, there is a written called how many resolutions a company passed, they have to upload in the portal, MCA portal every monthly or yearly. Like that, all associations should have a compliance mechanism, regulatory body.
Correct.
What are the resolutions they passed, how much quorum is there, and 2/3 majority is qualified.
I understood completely because almost all the things in apartment, every day apartment owners are coming and say, see, this problem, the legal answer in the sense, as I said, the principle of estoppel comes. What exactly it says? You had an option to go there. You didn't go. And how strong is your quorum is also one point. So normally in a quorum, you have to give an option if the apartment owners are not come. If your meeting is at 10, if the apartment owners are not come, 1 hour time, a gap, you can give it. And at 11 o'clock, you can start it. How strong is your bylaw? We have to cross-check it. And as you pointed out, IT Act is very clearly mentioned that online meetings can also be. So please create a mechanism where every apartment, we can as a group, we can think about it as a mechanism. You are the one who can guide me well because you are technologically advanced one. What we can do for making the participation more? As she pointed out, she's an NRI or someone, she can also sit there, she can vote it. So those kind of mechanisms we have to. Legally, this association is not valid. This 15-1, what you have done, now if we challenge it, it is difficult to stand before law.
The question is, at least for the future, regulatory mechanism should be there.
Please.
At least if you make mandatory, the participation will be there. Otherwise, it won't be. I'm asking for a general. No.
Bylaw, yeah, that can be.
Bylaw specifically is stating that
In person. Is there any provision in your bylaws? No, what I'm saying, some bylaws are specifically mentioning in person. So you put it for general body meeting and pass a resolution. That was enough for you. Huh? Huh? Old means? Huh? Huh? 1972? Huh? See, general body meeting is enough for that. Because it is a legally accepted mechanism as per IT Act. No, I'm not saying that you can create a new set of bylaw. I'm talking about the mechanism of voting online. That can be done. But for changing the bylaw amendment, for the amendment, you need majority. A general body meeting. You have to call a general body meeting and put this forward. What are the amendments you want to make? You have to. 3/4.
Let me specify. The DOD clearly says if you want to edit the DOD, you need 75% of all owners present in person to agree to it.
That in person can be overcome through a resolution. That's what I said. That can be done. Then you just put it on online. You can do that.
Sir, I have just 2 words for you. I have to leave, ma'am. Just 2 words for you. Addi poli.
Thank you.
Because, ma'am, I have never seen a senior legal counsel. I have just 2 words for you and your team. Addi poli. It basically means I have never seen a legal counsel take time out to answer. You have a fantastic time. True. And we hope to continue to work.
Thank you so much. We will create a group, of course. Yeah. I got my energy.
On the same note, on behalf of Almond Tree Association, Row Houses and Willamins, and the entire gathering here, I really want to thank you, ma'am, and BAF, Mr. Ramesh Padmanabhan, for the illustrative session. Thank you. We have many more such sessions to change the ecosystem.
Please.
And for providing the platform. Thank you for the bottom of my heart. And thank you for all the refreshments. It really takes efforts to organize such a mammoth task. So we are loads of gratitude. And
we will continue with these sessions, definitely. Thank you so much for attending also. Any questions didn't I answer?
I have. UDS is not there.
Why? When did they execute the sale deed? When? Are you sure that there is no DOD? Okay. But at least the DOD they have. Just see that advantage of executing the DOD. In the sale deed it is not there. In the DOD it is there.
Ma'am, I have.
Okay, fine, sir. You just show to me the document. I'll see.
Ma'am.
You come.
Ma'am, I have one more query here.
Ma'am, I am from Parasmani Regency apartment for which you have drafted the bylaw. Somehow it has not gained any traction and I have seen the bylaws. I have in fact made some suggestions to the bylaws. So I just want to know the actual ground reality of not registration.
That is another thing. There is a cooperative group. They are threatening everywhere. So this loophole people have mentioned, no, everyone has to sign. Right? Your property is also sold. Without, they had filed many cases against the sub-registrars. Criminal cases also. Saying that I hadn't signed this, but even then DOD is registered. Now sub-registrars are worried about that. No government officials will be, they will not be ready to come. So that is what sub-register office, Next Legal is the only one who is doing the deed of declaration, that too with a lot of difficulties. Yours will also be done. Give us some time. This is the reality.
Got it. And deed of declaration is to be signed by both the owner and builder.
All the apartment.
And one more quick question, ma'am, on the parking.
Hello. Sukanya is also very good in...
I'm Sukanya.
Yeah, I'd like to finish that. See, my doubt is our apartment has a registered DOD under Apartments Act 1972.
Okay, builder has done that.
Has done it. So everyone who's basically doing the sale deed is getting it signed. That is sorted over there. But then I am the next association member. Prior what they have told, we have sent this particular document to RWA. RWA is not accepting it. They have clearly told we do not.
Draft you are talking about.
Yeah, the DOD
Deed of-
has gone, the election results have gone, everything has gone.
DOD is registered.
Registered.
Huh.
They have told we will not accept anything which is of 1972, only 1960 is what we will accept.
I can give you a case law. There is a direction to the society's registrar. Don't do this. A clear direction from the court.
They have sent it back.
Then you just coordinate with Soundarya. She will right away send it to you. Your number. Just in the group, I'll do one thing in the group. Certain legal points we will mention. I mean, some clip. So whatever I can do, I'll put it in the group. Be a part of the group. Right?
And certain other things that you have pointed out in terms of, as you said, the committee is responsible, like the snake, the issue that happened. Now, see, this is maybe common area. Some of them, of course, putting their batteries, their whatever articles, wherever they feel like, in the common area. Even if the warnings are given, penalties are put, are we legally allowed to move it out?
After giving a lot of
Warning, penalty,
warnings and everything, you remove it.
Committee is not responsible.
You can also give an explanation mentioning that these kinds of things are happening. We are responsible for them. But send proper communication to the owner in case if you want a legal notice also.
No, in EGM we have got this approval and sent, put it on.
Car parking area is only for car parking.
Okay.
That you have to understand. If it is an individual house, in your car parking area, whatever you want, you can put it. But when it is a community living, whatever is meant for or that area, there you can put only that.
My final query on legal.
Can the DOD be revised?
Amendment can be done. Before the OC. OC is not a... You can amend it. OC is not a condition for occupancy certificate is not required for. Yes, yes.
No, I have one final query regarding RERA and legality.
No, but your sale deed is not executed, right?
Sale deed is executed.
Executed, but occupancy certificate you didn't receive. Sale deed is done. Without occupancy.
Ma'am,
then you are safe. You are lucky.
Ma'am, we are.
Who has to leave?
Shabir sir, he's actually waiting.
Ma'am, only one small question.
Shabir, thank you so much. His performance was also very wonderful, no? Yeah. Thank you so much. I'll keep in touch. Huh? Yeah. Tomorrow itself I'll call you.
Ma'am, one small question, ma'am. Yeah, please.
Final query I have in terms of RERA. The validity, as you said, is for 5 years. RERA warranty is for a 5-year period, right?
Warranty for construction.
Yes. Now, builders are playing very smart in this way. Whatever you're building, structure, clubhouse, one part. Rest of the common area, landscaping, swimming pool, all that as the second part. They are handing over the building and stating from that day and the OC date onwards, RERA, whatever warranty starts. This, if they have completed, let's say, only 2 years back, they still state we have handed over. We have not accepted the handed over. We have formally written to them that we are not accepting your handover because of these issues. But they clearly state, as per RERA, we are through. We can't do anything.
No, handover you should not accept like, kind of a handing over a key. Handover is there's a lot of procedure connected. You have to cross-check all your sale deeds and a lot of things you have to cross-check. You pointed out the warranty issue. You capture everything in an agreement and then accept it.
See, as I said, I am the next. After 2 years, I have now taken over. Previous association, this has not happened. Now, what is the solution?
No, there is no point in saying previous and all. Now the solution already accepted.
They have also, no one has taken the handover. It's only a mail from the developer.
And then you demand for handover. You can just, is there any documentation which is mentioned that, project is handed over to you? Signed by you?
No, none of them.
I'll check it and then after that I'll give a solution.
Ma'am.
Some people are waiting for that. So I'm so, give me a second.